The legislative record provides a comprehensive examination of the intense confrontation between Representative Jim Jordan and Maya McGuinness regarding the constitutional validity of current immigration parole mechanisms. This dialogue serves as a focal point for a much larger national debate concerning the limits of executive discretion and the preservation of legislative supremacy in the American Republic. The representative begins his line of questioning by asserting that the administration has fundamentally transformed a narrow legal exception into a broad and unauthorized entry system. He argues that the sheer volume of individuals being processed, exceeding 500,000, indicates a systemic departure from the case-by-case adjudication required by federal statutes. This expansion is portrayed not as a routine administrative adjustment, but as a deliberate effort to bypass the checks and balances inherent in the United States government. The core of the dispute lies in the interpretation of the Immigration and Nationality Act, specifically the sections governing the temporary admission of foreign nationals. Jordan contends that the executive branch is currently engaged in an unprecedented overreach that undermines the authority of the people's elected representatives in Congress. By allowing hundreds of thousands of migrants to enter the interior without traditional visa vetting, the administration is accused of creating a parallel immigration framework. This perspective suggests that the rule of law is being sacrificed in favor of political expediency and administrative convenience at the highest levels. The representative emphasizes that such a significant shift in national policy requires a legislative mandate that does not currently exist under the present legal code. During the exchange, the official under inquiry defends the implementation of these parole programs as vital components of a modern, flexible border management strategy. These programs are characterized as lawful pathways designed to alleviate the pressure on physical border infrastructure and reduce the incentives for illegal crossings. The administration's stance is that in the face of global migration surges, the executive must utilize every tool at its disposal to maintain a semblance of order. Proponents argue that these measures allow for a more controlled and vetted process than the chaotic alternative of undocumented entries across the southern frontier. This defense relies on the idea that executive flexibility is necessary to handle crises that the legislative process is too slow or too divided to address. However, the counterargument presented in the transcript describes these actions as a unilateral rewrite of federal law that ignores the clear intent of the framers. The representative points out that the parole power was historically intended for urgent humanitarian reasons or significant public benefit on an individual basis. He suggests that using this power to admit entire categories of people based on nationality or economic status is a direct violation of the law's original scope. This creates a situation where the executive branch is essentially legislating from the White House, a move that critics view as a threat to the separation of powers. The dialogue reflects a deep skepticism regarding the administration's claim that these pathways are truly lawful in the traditional sense of the word. The discussion then shifts toward the long-term implications of these policies, specifically focusing on the potential for what critics label as chain migration through administrative fiat. When large groups are paroled into the country, they often receive work authorizations and other benefits that integrate them into the domestic socio-economic fabric. This integration, Jordan argues, sets the stage for future legal status and the eventual sponsorship of additional family members from abroad. This downstream effect is seen as a way for the administration to expand the immigrant population without seeking the consent of the American electorate. The transcript captures the frustration of those who believe that the fundamental makeup of the nation should be determined by laws, not by memo-driven policies. The tension between the two participants highlights the profound political schism that currently defines the American approach to sovereignty and border security. On one side, there is a call for strict adherence to the letter of the law and the preservation of congressional authority over all immigration levels. On the other side, There is an emphasis on the need for administrative pragmatism and the humane management of people seeking entry into the United States. This clash is not merely about numbers or logistics. It is a fundamental disagreement over the nature of executive power in the 21st century. The representative's questioning aims to expose what he perceives as a blatant disregard for the constitutional boundaries that prevent any one branch from becoming too powerful. Furthermore, the record examines the fiscal and social impact of these parole programs on local municipalities and state governments across the country. The representative argues that the sudden arrival of hundreds of thousands of paroled individuals places an unfathomable burden on public schools, healthcare systems, and emergency services. He posits that the federal government is shifting the costs of its policy choices onto local taxpayers who never agreed to these massive population shifts. This line of reasoning connects the high-level legal debate to the tangible realities faced by citizens in their everyday lives. By highlighting these costs, the inquiry seeks to demonstrate that the executive's discretion has real-world consequences that go far beyond the halls of the Department of Homeland Security. In her responses, McGuinness attempts to balance the fiscal concerns with the reality of the global humanitarian situation and the complexities of international diplomacy. The official position maintains that providing organized pathways is actually more cost-effective in the long run than managing a perpetual border crisis. By vetting individuals before they arrive, the government argues it can better allocate resources and ensure that those who are admitted do not pose a threat to national security. This perspective views the parole system as a necessary evil in a world where the legislative branch has failed to pass comprehensive immigration reform for decades. The defense suggests that the executive is simply filling a vacuum left by a dysfunctional and polarized Congress. The debate also touches upon the historical usage of parole by previous administrations, with the current official citing precedents from both political parties. However, the representative quickly counters that no previous administration has used the parole power with such frequency or on such a massive scale. He argues that the current parole-for-all approach is a qualitative change from the limited, specific uses of the past. This historical comparison is crucial to the argument that the current administration has broken with decades of established legal tradition. The inquiry suggests that the scale of the current programs makes them fundamentally different from anything the country has seen before, requiring a much higher level of scrutiny. The transcript concludes this section of the inquiry by underscoring the lack of transparency regarding the vetting process for those being paroled into the country. Jordan expresses deep concern that the expedited nature of these programs may allow individuals with criminal backgrounds or extremist ties to slip through the cracks. He argues that the rush to process as many people as possible has compromised the safety of the American public. The administration, meanwhile, insists that its vetting procedures are robust and that these pathways actually provide more data on entrants than would otherwise be available. This disagreement over security highlights the total lack of trust between the two branches of government on the issue of border control. Ultimately, the text reflects a nation at a crossroads, struggling to reconcile its identity as a land of laws with its history as a destination for those seeking opportunity. The representative's aggressive questioning is a manifestation of the belief that the government must be held accountable to the statutes as they are written. The official's defense represents a belief in the necessity of a strong, active executive that can navigate the nuances of a complex world. As the session progresses, it becomes clear that there is very little middle ground to be found between these two competing visions of American governance. This transcript serves as a permanent record of a moment when the very definitions of legality, authority, and sovereignty were being contested in the highest chambers of power. Moving into the second phase of this legislative examination, the focus shifts toward the specific administrative mechanisms that allow for such broad applications of executive discretion. Representative Jim Jordan continues to press for a granular explanation of the vetting protocols, questioning whether the Department of Homeland Security is effectively rubber-stamping entries to meet political quotas. He posits that the current framework creates a perverse incentive structure, where the mere act of arriving at a port of entry or using a government-sanctioned mobile application guarantees a level of legal protection not envisioned by the authors of the original statute. The representative argues that this digital border is a facade that masks the reality of a wide-open gateway, where the rigor of traditional background checks is sacrificed for the sake of processing speed and optical management. This critique suggests that the administration is prioritizing the appearance of order over the substance of national security, a trade-off that critics find fundamentally unacceptable. The dialogue further explores the economic ramifications of paroling hundreds of thousands of individuals into the labor market without explicit congressional authorization. The legislator raises concerns that an artificial influx of low-skilled labor, facilitated through executive fiat, places downward pressure on the wages of American citizens, particularly those in vulnerable socioeconomic sectors. He argues that by bypassing the labor certifications required for traditional work visas, the administration is unilaterally altering the domestic economic landscape. This perspective views the parole programs not just as a border management tool, but as a backdoor economic policy that favors foreign nationals over the domestic workforce. The inquiry seeks to highlight the disconnect between the administration's stated goals of protecting American workers and its actions that appear to dilute the value of domestic labor through administrative overreach. In response, the official record reflects a defense centered on the concept of orderly processing as a means of mitigating the chaos of traditional illegal crossings. The administration contends that by providing a structured pathway, they can better track individuals as they move through the judicial system. They argue that the alternative, a complete reliance on enforcement and removal, is physically and fiscally impossible given the current levels of global instability. This viewpoint characterizes the parole system as a pragmatic response to a broken status quo, where the executive branch must innovate to prevent a total breakdown of the asylum system. Proponents suggest that the data collected through these new pathways provides a level of intelligence and oversight that was previously non-existent during periods of mass undocumented entry. The confrontation then delves into the legal definition of significant public benefit, which is one of the two statutory justifications for granting parole. Jordan argues that the administration has stretched this definition beyond all recognition, applying it to vast swaths of the population rather than to specific, individual cases. He maintains that the benefit mentioned in the law was intended to apply to witnesses in criminal trials or individuals providing vital intelligence, not to hundreds of thousands of economic migrants. This linguistic and legal battle is central to the disagreement, as it touches on whether the executive has the power to redefine statutory terms through internal memoranda. The representative's line of questioning aims to demonstrate that if significant public benefit can mean anything the president wants it to mean, then the law effectively means nothing at all. Furthermore, the transcript examines the role of non-governmental organizations in the administration's parole strategy, with critics suggesting a symbiotic relationship that circumvents public accountability. The representative questions the flow of federal funds to these entities, which are often tasked with transporting and housing paroled individuals once they are released into the interior. He argues that this creates a taxpayer-funded infrastructure designed to facilitate and encourage further migration, creating a self-perpetuating cycle that is outside the control of the electorate. This aspect of the inquiry seeks to expose the underlying machinery of the parole system, portraying it as a coordinated effort between the federal government and private interests to fundamentally change the nation's demographic profile. The dialogue reflects a deep suspicion that these administrative actions are part of a broader ideological agenda that transcends simple border management. As the session continues, the discussion turns to the issue of temporary status, with the legislator pointing out that many of those paroled are given stay periods that are repeatedly extended. He argues that there is nothing truly temporary about a program that allows individuals to remain in the country for years while their asylum claims languish in an overburdened court system. This permanent temporariness is described as a legal fiction that allows the administration to grant the benefits of legal residency without the official title. The representative contends that this de facto amnesty is a betrayal of the millions of people around the world who are waiting to enter the country through legal, congressionally approved channels. By creating a fast track for those who arrive at the border, the administration is accused of rewarding those who bypass the system at the expense of those who follow the rules. The defense, however, points to the inherent volatility of international crises, such as the collapse of civil order in certain Caribbean and South American nations, as justification for these extraordinary measures. The administration argues that it cannot simply ignore the human reality of thousands of people fleeing violence and economic ruin. They posit that the parole power is the only flexible tool available to prevent a humanitarian catastrophe on the nation's doorstep. This perspective frames the debate as a choice between a rigid adherence to outdated laws and a compassionate, responsive approach to global suffering. The official's testimony emphasizes that the executive has a moral and practical obligation to act when the stakes are so high, even if the legal path is unconventional. This portion of the inquiry also touches on the lack of cooperation from the migrants' home countries, which often refuse to accept the return of their citizens. The administration argues that parole is a necessary management tool when deportation is not a viable option due to diplomatic hurdles. Jordan counters that this excuse effectively gives foreign dictators a veto over American immigration policy, as their refusal to cooperate forces the U.S. to admit their citizens. He suggests that the administration should be using more aggressive diplomatic and economic leverage to force these countries to take back their nationals, rather than simply paroling them into the United States. This exchange highlights the intersection of immigration policy and foreign relations, illustrating how domestic administrative choices are deeply intertwined with global power dynamics. The transcript then documents a sharp disagreement over the transparency of the data regarding the number of paroled individuals who failed to appear for their court dates. The representative alleges that the administration is intentionally obscuring these figures to hide the failure of its policies. He argues that the orderly pathways are, in reality, a catch-and-release system on a massive scale, where a significant percentage of entrants disappear into the shadows of the country. The administration maintains that its tracking systems are effective and that the majority of paroled individuals comply with their legal obligations. This dispute over the facts and figures underscores the total breakdown of communication and trust between the legislative and executive branches, as both sides operate from entirely different sets of data and assumptions. Finally, this section of the record reflects on the judicial challenges to these parole programs, as several states have sued the federal government to halt their implementation. The representative highlights these legal battles as evidence that the administration's actions are widely viewed as unconstitutional. He argues that the states are bearing the brunt of the federal government's refusal to enforce the law, and that their legal standing is rooted in the tangible harm caused by the influx of migrants. The administration, in turn, defends its authority in court, asserting that the federal government has exclusive jurisdiction over immigration and that the states are overstepping their bounds. This legal stalemate adds another layer of complexity to the debate, as the third branch of government is increasingly called upon to mediate a conflict that the political branches seem unable to resolve. The third segment of this extensive legislative inquiry transitions into the broader geopolitical and socio-economic consequences of what the representative characterizes as a systemic dismantling of the interior enforcement apparatus. Representative Jim Jordan intensifies his critique by examining the intersection of parole policies and the operational capacity of federal law enforcement agencies. He suggests that by reallocating resources to facilitate the processing of paroled individuals, the administration is effectively depleting the manpower necessary for border interdiction and criminal investigations. This shift in priority, he argues, creates a vacuum that is exploited by transnational criminal organizations involved in the trafficking of narcotics and human beings. The legislator posits that the lawful pathways serves as a distraction from a deteriorating security situation, where the focus has moved from deterrence to social service provision. The dialogue then scrutinizes the psychological impact of these policies on prospective migrants worldwide, introducing the concept of pull factors as a primary driver of the current crisis. The representative contends that when the global community observes hundreds of thousands of individuals being paroled and given work permits, it sends a clear signal that the American border is effectively porous. He maintains that the administration's rhetoric regarding consequences is undermined by the reality of widespread releases, which incentivizes more people to undertake the dangerous journey to the United States. This perspective views the parole framework not as a solution to the surge, but as a fundamental cause of its continued escalation. The inquiry seeks to demonstrate that administrative leniency at the border creates a self-fulfilling prophecy of ever-increasing migratory pressure that no amount of processing capacity can ever truly satisfy. In contrast, the official record presents a defense that emphasizes the necessity of regional cooperation and the stabilization of the Western Hemisphere. The administration argues that these parole programs are part of a multilateral strategy to share the responsibility of migration management with neighboring countries. By creating formal channels for specific nationalities, the government claims it can incentivize partner nations to strengthen their own border controls and accept the return of those who do not qualify for the programs. This viewpoint frames the domestic parole policy as a critical component of American soft power and diplomatic leverage in a highly volatile region. Proponents suggest that a purely enforcement-based approach would alienate regional allies and leave the United States to handle the migration crisis in isolation. The confrontation further investigates the specific criteria used to grant work authorizations to those entering under the parole umbrella. Jordan argues that the rapid issuance of these permits bypasses the protections designed to ensure that foreign labor does not displace domestic workers or depress local wages. He expresses concern that the executive branch is using the parole power to create a massive, unauthorized work program that avoids the scrutiny of the Department of Labor. This line of questioning focuses on the economic sovereignty of American citizens, suggesting that their interests are being sacrificed to accommodate the administration's humanitarian objectives. The representative emphasizes that the right to work in the United States is a privilege defined by statute, not an administrative benefit to be distributed at the discretion of the presidency. Furthermore, the transcript explores the long-term fiscal liabilities that paroled individuals may represent for the American taxpayer, particularly regarding social safety net programs. The representative points out that while paroled individuals are generally ineligible for many federal benefits, the costs of their presence often fall on state and local governments. He highlights the increased demand for emergency room services, subsidized housing, and specialized educational programs for non-English speaking students as hidden costs of the administration's policies. This argument attempts to quantify the significant public benefit from the perspective of the American taxpayer, reaching a conclusion that stands in stark contrast to the administration's justifications. The dialogue underscores a fundamental disagreement over whether the executive branch has the moral authority to impose such significant fiscal burdens on the citizenry without legislative consent. As the session continues, the discussion turns to the issue of national sovereignty and the integrity of the visa system that has been the cornerstone of American immigration policy for decades. The legislator argues that by allowing individuals to cut the line through parole, the administration is insulting the millions of people who are following the legal process. He highlights the stories of individuals who have waited years for their visa interviews, only to see others granted entry and work rights almost immediately upon arrival at the border. This sense of unfairness is used to frame the parole programs as an attack on the very concept of legal immigration and the principle of equality before the law. The representative contends that the administration is creating a tiered system where those who break the rules are prioritized over those who respect them. The defense, however, counters that the current visa backlog is itself a product of congressional inaction and the failure to provide adequate funding for consular services. The administration argues that they are forced to use parole because the traditional system is so broken that it can no longer function in a timely or humane manner. They posit that it is better to have a vetted, paroled individual in the country than an unvetted, undocumented one living in the shadows. This perspective views the choice not as between legal and illegal entry, but between controlled and uncontrolled migration in a world where the old rules no longer apply. The official's testimony emphasizes that the executive branch is attempting to manage a global reality that Congress has refused to acknowledge or address through modern legislation. This portion of the inquiry also touches on the security vetting of paroled individuals, specifically the reliance on foreign government databases that may be incomplete or intentionally misleading. Jordan expresses deep skepticism that the administration can truly know the backgrounds of people coming from countries with hostile regimes or failed institutional infrastructures. He argues that the vetting process is only as good as the data provided, and that in many cases, there is no reliable data to be had. This highlights a critical vulnerability in the parole system, where the desire for administrative efficiency may lead to catastrophic security failures. The representative suggests that the administration is taking an unacceptable risk with the lives of American citizens by admitting such large numbers of people from unstable regions without foolproof background checks. The transcript then documents a debate over the role of the judiciary in interpreting the limits of the parole power, with the representative calling for a strict constructionist view of the law. He argues that the courts have historically been too deferential to the executive on matters of immigration, allowing the presidency to gradually usurp powers that belong to the people's representatives. He suggests that the current expansion of parole represents a tipping point that requires a robust judicial intervention to restore the constitutional balance. The administration, meanwhile, cites a long line of legal precedents that affirm the president's broad authority to manage the border and conduct foreign affairs. This disagreement highlights the philosophical divide over the role of the third branch of government in policing the boundaries between the other two. Finally, this section of the record reflects on the broader cultural and social cohesion of the nation in the face of rapid, administratively driven demographic changes. The representative raises concerns that the scale and speed of the current influx make it difficult for new arrivals to integrate into American society, potentially leading to social fragmentation. He argues that immigration policy should be designed to foster a sense of national unity and shared values, rather than just managing the flow of bodies across a line. The administration, in turn, defends the diversity and resilience of the American tradition of welcoming those in need, arguing that the country has always been strengthened by new arrivals. This debate over the soul of the nation illustrates how the technical details of parole policy are inextricably linked to the most profound questions of American identity and the future of the Republic. In the fourth chapter of this exhaustive inquiry, the dialogue intensifies as it pivots toward the systemic implications of the administration's lawful pathways on the integrity of the broader American legal framework. Representative Jim Jordan highlights what he describes as a radical departure from the foundational principle of case-by-case adjudication. He suggests that by processing hundreds of thousands of individuals through specialized mobile applications and categorical designations, the executive branch has effectively replaced statutory law with administrative convenience. This transition, the representative argues, creates a parole-first policy that incentivizes global populations to bypass traditional visa wait times in favor of immediate, albeit technically temporary, entry. The inquiry posits that such a shift does not merely manage a crisis but fundamentally alters the social contract between the government and those who follow the established legal order. The confrontation further examines the specific administrative directives that have paved the way for the massive influx of over 500,000 foreign nationals. The legislator contends that the administration's reliance on humanitarian and public benefit justifications is so broad that it renders the statutory language meaningless. He maintains that if the executive can grant parole to entire nationalities simultaneously, then the concept of an individual, merit-based, or case-by-case review has been discarded in favor of a mass entry system. This perspective views the current policy as a strategic end run around the legislative branch's plenary power to set immigration levels. The dialogue reflects a deep concern that the executive is using its discretionary power not to fill gaps in the law, but to create a new, parallel legal code that lacks the consent of the American electorate. In contrast, the official record offers a defense rooted in the necessity of operational agility within the Department of Homeland Security. The administration argues that the current global migration landscape, characterized by unprecedented instability in the Western Hemisphere, requires tools that can react faster than a gridlocked Congress. They present the parole programs as a sophisticated carrot-and-stick approach designed to channel migration into pre-vetted, orderly streams. This viewpoint suggests that by providing a predictable process for certain groups, the government can actually improve national security by identifying and screening individuals before they ever reach the physical border. Proponents argue that this method is far superior to the alternative of managing a constant, unvetted surge of people who cross into the interior undetected. However, the discussion quickly moves to the long-term socio-economic consequences of this administrative expansion, specifically focusing on the erosion of the interior enforcement mandate. The representative argues that when parole is granted on such a massive scale, it sends a clear message to the world that the United States is no longer serious about its immigration caps. He suggests that this perception fuels the very cycles of migration the administration claims to be managing, creating an endless loop of demand and administrative response. This line of questioning emphasizes the concept of pull factors, where the promise of work authorization and release into the interior serves as a powerful magnet for millions. The legislator maintains that the executive branch has effectively surrendered the primary tool of border security, deterrence, in favor of a system of facilitated entry that only exacerbates the problem. Furthermore, the transcript explores the legal battles brewing between the federal government and several states over the fiscal and social impacts of these parole initiatives. The representative highlights that state governments are increasingly forced to divert billions of dollars from their own citizens to provide services for paroled individuals. He argues that this constitutes an unfunded mandate imposed by the executive branch without the democratic oversight that would typically accompany such a massive reallocation of public resources. This aspect of the inquiry seeks to bridge the gap between abstract legal theory and the tangible reality of local communities struggling to absorb large, unplanned population shifts. The dialogue captures a sense of growing resentment among local officials who feel that their jurisdictions are being treated as processing centers for a federal experiment in border management. As the session continues, the focus shifts to the transparency of the vetting process and the potential for systemic fraud within the sponsorship mechanisms of the parole programs. Jordan expresses concern that the administration's rush to process large numbers of people has led to significant lapses in security screening. He cites reports of fraudulent sponsors and incomplete background checks, suggesting that the integrity of the system has been compromised for the sake of political optics. The representative argues that by prioritizing speed over security, The government is taking an unacceptable risk with the safety of American neighborhoods. This line of questioning aims to demonstrate that the lawful pathways are not as rigorous or as secure as the administration claims, potentially allowing dangerous individuals to gain legal status under the guise of humanitarian relief. The defense, meanwhile, points to the improved data collection and tracking capabilities inherent in the new parole processes as evidence of their efficacy. The administration maintains that because individuals must apply through digital platforms and provide biometric data, the government actually has more information on them than it would if they crossed the border illegally. They argue that these programs allow the federal government to proactively screen applicants against national security and criminal databases before they even begin their journey. This perspective frames the parole system as a technological evolution in border security, utilizing data and preemptive vetting to manage a complex human flow. The official's testimony emphasizes that the alternative, total reliance on physical barriers, is an outdated strategy that ignores the digital and globalized nature of modern migration. The transcript then documents a sharp exchange regarding the eventual legal status of those who have been paroled. The legislator argues that while the status is technically temporary, the history of American immigration indicates that few, if any, will ever truly be removed once they are integrated into the interior. He describes this as a slow-motion amnesty that creates a permanent residency track without the need for congressional approval. This perspective suggests that the administration is using parole to build a massive new constituency that will eventually be granted permanent status through future legislative or executive actions. The representative contends that this is a betrayal of the millions of legal immigrants who are following the rules and waiting years for their own chance to become Americans. This portion of the record also examines the impact of these policies on the morale and operational capacity of Border Patrol agents and other law enforcement personnel. The representative argues that agents are increasingly being pulled away from their primary mission of security to serve as administrative processes for paroled individuals. He suggests that this shift has led to a collapse in morale and a dangerous decrease in field presence along critical sections of the border. This highlight focuses on the opportunity cost of the parole programs, where the focus on processing newcomers comes at the expense of stopping the flow of narcotics and other illicit materials. The inquiry portrays the administration as being more concerned with the logistics of entry than with the fundamentals of national defense. Finally, this section of the transcript reflects on the constitutional implications of the executive branch's claim to exclusive jurisdiction over immigration matters. The representative challenges the idea that the president has a blank check to ignore or rewrite existing statutes whenever he deems it necessary. He argues that the separation of powers is being systematically eroded as the administration consolidates authority over national demographic policy. The inquiry concludes by underscoring the deep ideological chasm between those who believe in the strict enforcement of the law and those who believe in administrative flexibility as a tool for social and humanitarian progress. This record serves as a testament to a period of intense institutional friction, where the very boundaries of American governance were being re-evaluated in the face of a persistent and evolving border crisis. In this fifth and concluding section of the analysis, the inquiry moves into the high-stakes legal and political aftermath that defined the year 2025. The discourse surrounding Representative Jim Jordan and the broader legislative challenge to executive parole culminated in a significant constitutional pivot. As documented in the record, the tension between the two branches of government shifted from a debate over policy implementation to a rigorous judicial evaluation of executive termination powers. Jordan's argument that these programs represented a unilateral rewrite of federal law found renewed life as the administrative landscape changed drastically following the 2024 election. The legislator continued to emphasize that the mass entry of over 500,000 individuals was a structural failure that required not just a policy reversal, but a fundamental restoration of the case-by-case vetting standard mandated by the Immigration and Nationality Act. The record details the unprecedented legal volatility that occurred when the executive branch attempted to categorize these hundreds of thousands of paroled individuals for mass termination. This move sparked a flurry of litigation, with district courts initially staying the government's efforts to revoke status and work authorizations for nationals from Cuba, Haiti, Nicaragua, and Venezuela. The representative argued that the very same categorical approach he had initially criticized was now being used by the administration to rectify its previous overreach, leading to a legal paradox. Critics in the legislature pointed out that the government's attempt to end these lawful pathways, as swiftly as they had been created, was an admission that the original foundation was legally precarious. The dialogue illustrates a systemic struggle where the lives of hundreds of thousands of people became the subject of intense, competing interpretations of administrative law. The inquiry further documents the definitive intervention by the Supreme Court of the United States in May 2025, which fundamentally shifted the balance of power back toward the executive's enforcement mandates. The court's decision to lift preliminary injunctions that had protected paroled individuals allowed the Department of Homeland Security to proceed with the termination of these massive humanitarian programs. Representative Jordan characterized this ruling as a victory for the rule of law, suggesting that it finally checked an executive branch that had operated beyond its statutory leash for too long. However, the dissenters within the judicial and legislative spheres argued that this mass illegalization event ignored the individual reliance of those who had entered the country at the government's invitation. This clash highlights the profound ethical and legal complexity of undoing large-scale administrative programs once they have been integrated into the national fabric. Furthermore, the record examines the downstream effects of these court rulings on the domestic labor market and local communities. The representative contended that the removal of work authorizations was a necessary step to protect American workers from the downward pressure caused by an artificial influx of labor. Conversely, the official documentation reflects concerns that the sudden loss of status for 500,000 people would lead to a significant increase in the undocumented population, creating a new humanitarian crisis within the interior. The debate captures the conflict between the desire for strict legal adherence and the logistical reality of managing a population that has already established roots, sponsors, and employment. The discourse underscores the difficulty of retreating from expansive executive policies without causing significant socio-economic disruption. As the legislative session concludes, the discussion turns to the future of the parole power itself and the potential for permanent statutory changes to prevent future overreach. Representative Jordan and his colleagues proposed several measures to narrow the definition of significant public benefit and urgent humanitarian reasons, seeking to strip the executive branch of the flexibility that allowed the 500,000-person surge to occur. This move represents an attempt by the legislative branch to reclaim its plenary authority over immigration policy, which critics argue had been ceded to the presidency over decades of inaction. The inquiry serves as a blueprint for a more restrictive, law-bound approach to border management, where administrative discretion is the exception rather than the primary vehicle for entry. The dialogue reflects a belief that the survival of the separation of powers depends on the legislature's ability to provide clear, unambiguous rules that no president can bypass. The official record also touches upon the international implications of these domestic policy shifts, noting that regional allies were left to deal with the fallout of the sudden termination of parole pathways. The administration argued that the abrupt end of the programs undermined American credibility and destabilized the very nations the U.S. was trying to assist. Jordan countered that American sovereignty and the integrity of the federal code must always take precedence over international perceptions or diplomatic convenience. This exchange highlights the America First philosophy that gained significant traction during the 2025 legislative cycle, framing border security as the ultimate expression of national independence. The transcript documents a period where the United States intentionally distanced itself from multilateral migration agreements in favor of a strictly internal, enforcement-heavy posture. The tension during the inquiry also focused on the vetting center established by the government to handle the massive backlog of cases resulting from the termination of parole. The representative expressed skepticism about the efficacy of this new unit, questioning whether it would truly identify those who posed a threat to public safety or if it was merely another administrative layer. He argued that the lack of transparent data regarding the vetting of the original 530,000 individuals made it impossible to trust the government's current security claims. This line of questioning reflects a total erosion of trust between the branches of government, where every administrative action is viewed through a lens of political suspicion. The dialogue portrays a government that is more divided on the basic facts of border security than at any other point in modern history. Finally, the transcript reflects on the long-term demographic and social changes that the parole era has already set in motion, regardless of the eventual legal outcomes. The representative posited that the chain migration initiated by these programs would continue to impact the nation for generations, as individuals seek other legal avenues to stay or bring in family members. He argued that the administration's temporary fixes had created permanent sociological shifts that the American people never voted for. The inquiry ends with a somber assessment of the challenges ahead, acknowledging that the legal and political battles of 2025 are merely the beginning of a long-term effort to define the boundaries of the American state. This record stands as a critical account of a moment when the fundamental mechanics of the Republic were tested by the complexities of global migration and executive ambition. Ultimately, the text illustrates a nation grappling with the consequences of its own administrative power, caught between the ideals of humanitarianism and the necessity of the rule of law. The confrontation between Representative Jim Jordan and Maya McGuinness, while focused on specific figures and statutes, served as a proxy for the larger question of whether a modern democracy can maintain its identity while navigating the pressures of a world in constant motion. The 2025 developments, from the Supreme Court rulings to the mass termination of status, marked a turning point in the American story, a return to a more rigid, legislative-focused approach to national borders. This transcript captures the intellectual and political intensity of that transition, providing a professional and neutral record of one of the most consequential debates in contemporary American history.